Hello YouTube and welcome to my channel. This is my first video ever, so buckle up. It's going to be a bumpy ride. My name is Adam D'Angeli. I work professionally in politics, and on this channel I hope to talk about a lot of interesting political issues in the news, talk about all kinds of policy questions, political questions. But in this video, what I wanted to go over was a very sad story about what happened to Founders Brewing Company in a recent lawsuit. And it's not just about Founders, though. I think after this, we'll also take a look at what the implications are for other businesses in the future, and also how people use the legal system and how people use the media, or the fake news, as it were, for resolving their disputes, and what that means for potentially any business moving forward. So let's get into it. We're going to look at the story from start to finish here. So the story begins that Founders Brewing Company in Grand Rapids, Michigan fired an employee, and he sued them, saying that they fired him because he was black. And they pushed back and said, no, we fired him because he couldn't do his job. And as you can see from the date on this first story, this is, I think, the first news coverage of this in the major media. There might have been an earlier story about this, but this is from back in April. But the case was just resolved a couple of weeks ago. So, and that's typical of the legal system. It moves slowly. So we're going to kind of take it from the top here and go through this news article, which kind of lays out the groundwork for the story. So this is in the Detroit Metro Times, which, as we will see, played a major role in the outcome of the case through its journalism, as it were. But let's look at this early story and see what's going on here. So a federal judge has dismissed one claim in a racial discrimination lawsuit filed against Founders Brewing Company by a former black employee. However, the plaintiff can continue with several other claims that are part of the suit. The judge dismissed a claim that former employee Tracy Evans was passed over for promotion in favor of two less qualified white employees, but only did so because Founders requires employees to sign a highly unusual pre-employment agreement. It significantly shortens the statute of limitations in such lawsuits, and Founders wasn't actually cleared of wrongdoing. But Evans can proceed with claims that Founders retaliated against him for complaining about racism in the work environment and discrimination in how he was terminated. Those claims seek more in damage than what was dismissed. The decision also comes after Founders in December gave up on an arbitration case with Evans. Evans' attorney, Jack Schultz, said arbitration is a venue that's generally more favorable to businesses. But, quote, I think there was some indication that I had a strong argument and I could possibly win. Well, that's interesting, because why would arbitration be different than a court of law for finding of fact? And that's what's going on here. So if you file a lawsuit against somebody else and they can file a motion to dismiss, if in the text of the lawsuit they say there's no merits to the case, if you were to assume the facts in favor of the suing party, the plaintiff, but there was no legal basis for the lawsuit. But if there's a disputation about the essential facts, then there almost certainly has to be a trial, because that's the purpose of the trial, is to find fact. And the finder of fact, either the judge or the jury, is going to decide the truth of the matter. And then based on that, there'll be a determination. So we're going to look at the lawsuit. And the nice thing about the lawsuit is that there is a in the defendant's response, they go line by line through the initial complaint. So we have them both in one document. So at the same time as we're looking at the initial lawsuit, we can also look at the response of the defense. And this is from early on in the lawsuit. There's going to be several other things that have happened since then, but this is where it began. Let's also, wait, I have this article up. Okay, this is the Founders Company statement, and this is something that they put out on March 11th. So this is kind of still in the early stages of the lawsuit. This is 7.5 months ago. So the Founders Company statement: while companies are usually discouraged from commenting on pending litigation, and we have been advised to keep silent, usually your lawyer's got good advice in that respect, a recent legal case filed against Founders has been so grossly misconstrued that we feel compelled to speak out. Since our beginning nearly 22 years ago, Founders has been and will always be committed to promoting an inclusive and welcoming space for our customers and employees. Claims that we failed to address instances of racial bias in the workplace are completely false. Okay, so this is basically a blanket denial of all the charges. So what they're doing here is asserting that, no, this lawsuit is meritless. Please don't stop buying our beer. So let's just look at the lawsuit, because that's where we really get into what is going on, what the parties are alleging, what the plaintiff is alleging, and what the defense's responses are. So this is a answer to the first amended complaint, but what they're going to do is they're going to basically just read out the initial complaint. So it says, Defendant Canal Street Brewing Company, LLC, DBA Founders Brewing Company, by its attorneys, Miller Johnson, answers plaintiff's first amended complaint as follows. So now this first paragraph under introduction, this is not actually the defendant's response. This is the plaintiff's statement. So this is written by the plaintiff, and it's intended to present it all the facts, such as in the worst light possible against Founders. So here's what they say. Introduction. Plaintiff Tracy Evans was employed with the defendant Founders from 2014 until he was terminated in 2018. Shortly after notifying his supervisor, he planned to meet with Human Resources to discuss Founders' racist work environment. Is it Founders? Founders? I don't know. On information and belief, plaintiff was the first and only minority manager at Founders. To plaintiff's dismay, see there it says Founders, so it should be Founders' racist work environment. To plaintiff's dismay, his co-workers used racial slurs around him and with other employees. In fact, the company itself named its printers in a blatantly racist fashion. We'll see. Plaintiff complained to HR throughout his employment, but his complaints fell upon deaf ears. It is plaintiff's belief that he received unequal treatment throughout his employment and was denied a promotion due to his race. In late 2017, so, this is 2 years ago, a year and a half before the lawsuit, or wait, maybe 1 year before the lawsuit. This is October 2018, so this is quite a while ago. Lawsuits move slowly. In late 2017, plaintiff sought new beginnings within the company by moving to its newly opening Detroit taproom. However, he realized the same practices of ignoring racially insensitive comments and unequal treatment made their way into the new facility as well. After a few shockingly racist comments by a coworker and the company's failure to discipline the employee beyond a simple write-up, plaintiff notified his supervisor he intended to meet with Human Resources to discuss his treatment and ongoing issues. He was fired a few days later for pretextual reasons. Within this complaint, plaintiff alleges he received unequal treatment, was denied a promotion, and was ultimately terminated based upon his race, and in retaliation complaints regarding his treatment in violation of his rights under 42 U.S. Code Section 2000 and so on, 42 U.S.C. 1981, and the Michigan Elliott-Larsen Civil Rights Act, MCL 37.2101, and so on. That's what ITSEC means. Answer. Okay, so now this is the defense's reply to that first paragraph. Paragraph 1 of the complaint is introductory in nature, to which no response is required. To the extent a response is required, defendant refers to its answers to the allegations in paragraphs 2 to 61 contained herein. Okay, so this is just legalese here. They're saying we don't have to respond to this, but we're going to respond a little bit. Defendant further admits that plaintiff purports to bring claims against it for violation of 42 U.S.C. 1981 and Michigan's Elliott-Larsen Civil Rights Act, etc., but denies any and all liability with respect to plaintiff's claims, and denies that plaintiff is entitled to recovery in any amount and in any form. Defendant denies the remaining allegations in paragraph 1 of the complaint. Okay, so in a lawsuit, you're going to have a discovery period where the parties get to look at each other's records, essentially, their communications, and then as they go into court, they understand the basic facts, and then they argue about that, and then there's a determination. So they don't have to actually lay out their defense here. They just simply deny the allegations, and then if the case proceeds onward, then it's worked out at discovery and then at trial. So defendant denies the remaining allegations in paragraph 1 of the complaint. Okay, now we're going to the parties. Plaintiff Tracy Evans is an African-American individual who is employed with the defendant and resides in Wayne County, Michigan. Answer. Defendant admits it employed plaintiff in various positions from November 2013 to June 2018. Defendant further admits upon information and belief that plaintiff is an African-American individual. That's going to become a major point of contention when this becomes an issue in the news. But we're getting ahead of ourselves here. Defendant lacks knowledge or information sufficient to form a belief as to the truth of the remaining allegations in paragraph 2. Now, there aren't any other allegations in paragraph. Well, there is. There says he resides in Wayne County, Michigan. But they're not going to want to make that something that is going to be brought up in the lawsuit as a part of as a point of contention. So they're just saying we lack knowledge or information sufficient to form a belief as to that, and it's not relevant anyway. Defendant Canal Street Brewing Company, LLC, DBA Founders Brewing Company, is an LLC headquartered in Grand Rapids, Michigan. Founders Detroit Taproom is located at 456 Charlotte Street, Detroit, Wayne County, Michigan, 48201. Answer. Defendant admits that is in fact their business. Jurisdiction and venue, we can kind of skip over this because this was never controverted, but they sued in the proper court, basically. And they say the amount of controversy exceeds $75,000, exclusive interest, costs, and attorney's fees. That's what they I think, need to establish to get it to a real court as opposed to like a small claims court. Defendant denies that any amount is legitimately in controversy, but defendant does not dispute that this court has jurisdiction over this action subject to defendant's affirmative defenses. Okay, and on we go with the jurisdiction stuff, but that's not what's important. General allegations. Plaintiff Tracy Evans, plaintiff or Mr. Evans, is an African American and a member of a protected class based upon his race. Answer, defendant admits that's true. Plaintiff began working for the defendant Canal Street Brewing Company, founders, as a packaging machine operator in 2014 in its Grand Rapids, Michigan facility. Answer. Defendant admits that it hired plaintiff to work as a packaging machine operator in its facility in Grand Rapids, Michigan, and that plaintiff's employment began on November 4th, 2013. After completing defendant's orientation process on October 29th, 2013, defendant denies all remaining allegations in this paragraph because they are untrue. So right off the bat, Founders is pointing out that the plaintiff's allegations are already suspect because they get the year wrong that he began working at Founders. So they're making the point right there that already some of the things here are not accurate, at least what they're contending. And notice that they're using the exact dates here. They note the date that the defendant's orientation process was completed. So they're also saying we've got good records here. When plaintiff first started at the production facility, plaintiff was one of 3 total minorities out of more than 70 employees. Upon leaving, plaintiff was one of an estimated 7 minorities out of close to 200 employees. Answer, defendant lacks knowledge or information sufficient to form a belief as to the truth of the allegations in paragraph 10. And why would they? Because they don't ask on their employment applications what your race is. So, and this is also going to come up in a big way later on, but they're saying, we don't necessarily know what any individual employee's status is as a protected minority, whether they're white or look white but might be Hispanic or what have you. They don't know. So they're saying we don't know if this is accurate or not. This is just what the plaintiff is saying. He's saying I was only one of 3 minorities or 3 black employees or whatever it was out of more than 70 at the time, and now there's only a few of us out of close to 200 employees. And I don't know why they didn't address how many employees they actually have, because my understanding is that Founders actually has a lot more than close to 200 employees, but I don't know. We'll see. Within his first year, plaintiff was promoted to second assistant shift lead for the production department. Plaintiff was the only minority out of around 8 total assistant shift leads. Answer, defendant denies that plaintiff was promoted to assistant shift lead within his first year. So again, they're picking at the facts here just a little bit. Also, by the way, note that in their complaint, the plaintiffs say that he was promoted. So if he was passed over for promotions later, that works against their case that he was systematically denied promotions because they've said he was promoted. The defendant also denies there were, quote, around 8 total assistant shift leads. In further answer, defendant promoted plaintiff to second shift assistant lead on November 30th, 2014, and plaintiff was one of 5 assistant shift lead positions in the production department at that time. Defendant is without knowledge or information sufficient to form a belief as to the truth of the allegation that plaintiff was the only minority assistant shift lead. And again, they're saying we don't know how many minorities there actually are because we don't judge people on the color of their skin as a determination of whether or not they're a member of a protected class. Because it's iffy, you could say I look white, but do you know? Do you know what percentage I am white? I don't actually know. I haven't done a DNA test, but that's an issue. Is that And again, we'll see this in a big way soon enough, that the question of whether or not they can tell by someone's appearance what their racial status is unclear. All right, moving on. During his employment, and again, what's not in bold is what the plaintiffs are saying, and then what's in bold is the defense's answer to the complaint. During his employment, plaintiff was subjected to disparate scrutiny and disciplinary actions when compared to his Caucasian comparators. Answer, defendant denies the allegation because it's untrue. And they always say denies the allegations, even though this seems to be a singular thing. I think that's just a matter of keeping with a standard form in case they want to make an issue out of it and say that, no, you didn't deny all the allegations in the paragraph, and this is actually multiple allegations. And again, they're not definitively saying, here's how we understand that this is untrue, because that's something that would come up not now, but later on at a trial. In one instance, plaintiff was written up for being 1 to 3 minutes late consistently. However, his white coworkers were equally, if not more frequently, late. Now think about your own work environment. How well do you keep track of your coworkers' lateness? You might notice it, but do you really keep score? I don't know. I don't think most employees do that for most other employees. So they're saying this, but if this actually comes to contention at trial, the plaintiff would have an uphill battle to prove that this is true. And here the defendant denies it. Defendant admits that plaintiff received a verbal warning on May 5th, 2014 for tardiness after plaintiff was late for 26 of his previously 53 scheduled shifts, and on average was 6 minutes late for those shifts. Okay, so once again, they're establishing we are keeping records. We know he was late for exactly 26 of those the previous 53 scheduled shifts. And of course they would, because most workplaces keep careful track of exactly when every employee clocks in. And they say he was late on average for 6 minutes, and that's an important statement because typically you're considered late if you're more than 5 minutes late. So again, they're keeping careful count here, and again they say deny the remaining allegations because they're untrue. Around 2015, plaintiff was appalled to find that Founders had electronically named its printers in a manner blatantly racist to African Americans. Specifically, the facility's upstairs printer was used by management employees was named the white guy printer, and the downstairs general employee printer was named the black guy printer. Do you believe this allegation? Well, let's think about this here. First of all, according to the plaintiff, he was one of only a small number of black employees, period. So why would the downstairs general employee printer be called the black guy printer if almost all the other employees were not black? And why would they do something so blatantly racist? Let's assume the worst, assuming that Founders actually was run by a bunch of white nationalists. Why would they label a printer for all employees to see the black guy printer? Would any company with legal representation, and again, Founders is not a small, Founders is the most successful brewery in Michigan. They distribute globally, they distribute to all 50 states. They have 2 tap rooms. If you've been to the Founders Brewery in Grand Rapids, it's a huge brewery. It's enormous. Why would, and for what purpose? Also, by the way, notice they don't say how the printer was named. Was it typed on a little sticky note attached to the printer? Was it the name of the printer on the network? Notice these details are not in the complaint. Answer: defendant denies the allegations because they're untrue. Plaintiff was also denied a promotion due to his race. In late 2015, plaintiff applied for a promotion as a production lead. Plaintiff was one of 3 employees to apply for 2 openings. The other 2 Caucasian individuals were ultimately promoted to the positions despite being trained by plaintiff, directly by plaintiff, and being with the company for a shorter amount of time. That's not entirely relevant. That doesn't mean you're the best employee. Additionally, these Caucasian individuals each had a recent terminable incident shortly before their promotions at a company party. One employee crashed his vehicle into a parked car while intoxicated, and the other exposed his genitalia to partygoers. Ooh, that's bad. It's very bad. Although plaintiff had no such incidents in his employment history, both individuals were selected for the promotion over him. What does the defense say to this? Defendant admits that plaintiff applied for the position of production lead in October 2016, and that at that time there was only 1 opening for a production lead, but that another production lead position opened up a short time later. Defendant admits that plaintiff was one of 3 assistant shift leads to apply for this position, and that the other 2 assistant shift leads were selected for the position. Upon information and belief, defendant admits that the 2 assistant shift leads selected for the production lead positions were Caucasian, and that those individuals began employment at defendant a short time after the plaintiff. Defendant denies the remaining allegations in paragraph 15 because they're untrue. Darn, I guess we don't get to know. Because, well, there was a discovery period, but I don't have those discovery documents, so I don't know whether or not those things actually happened. But at any rate, defendant denies it. So that would be resolved at trial. And again, they wouldn't just have to prove that these incidents happened, that the employee was driving drunk and the other employee exposed his genitals. They'd have to show that that was ignored by the plaintiff or by the defendant in not promoting him over them. And also they have to show that there was no other reason why they were promoted over him. In October 2017, plaintiff saw an opportunity for a change and applied for a lateral transfer as the events and promotions manager in the newly opening taproom in Detroit. Answer: defendant admits in the August 2017 plaintiff applied for a promotion to events and promotion manager for the soon to be open Detroit taproom. Defendant denies the remaining allegations because they're untrue. Again, I don't see any other allegations in that paragraph, but they're covering the bases. Prior to moving to Detroit, plaintiff was approached by a Caucasian employee who exclaimed, "What's up with Detroit, my N-word?" Plaintiff immediately told the employee that it was not right for him to say this statement. Plaintiff also reported the employee to Human Resources. Okay, so we see Founders has a Human Resources department. So that's important because a small business, a very small tap room, if it doesn't have a Human Resources department, might be doing things informally. But they have a Human Resources department that shows that they're probably doing things by the book and probably not calling their printer a black guy printer. However, the employee continued to work with Founders for Plaintiff. Answer. Defendant admits that plaintiff voiced a complaint to its Human Resources Department in September 17 that a coworker who continues to work for the defendant approached him and made the comment alleged in paragraph 17. In further answer, upon receiving this report, defendant's Human Resources representative spoke with plaintiff and told plaintiff that she would investigate the allegation and that the offending employee would face disciplinary action if the allegation was substantiated. Plaintiff responded that he did not want the offending employee to be fired and preferred to have a conversation with the offending employee about the comment. Does this sound plausible? A white employee says to a black employee, "What's up my N-word?" Black employee complains to Human Resources. Human Resources says, "We'll discipline him if it's substantiated that this is what actually happened." He says, "Oh no, don't fire him. It's not that big of a deal." That sounds like something that probably could have happened. Where were we? Defendant's Human Resources representative then investigated plaintiff's complaint and took prompt remedial measures to cause this conduct to cease, including issuing a disciplinary action to plaintiff's coworker. Upon information and belief, plaintiff and the offending coworker met, and the offending coworker apologized, and plaintiff accepted his apology. That sounds like something that probably also happened. Human Resources says, "We're going to discipline this guy if this is merited." He says, "Well, don't fire him. It's not that big of a deal." They get together. He apologizes. Water under the bridge. Probably say, "Don't ever say that again." Defendant denies all remaining allegations in paragraph 17. Now, maybe Founders should have fired the employee for saying the N-word the first time. Or maybe not. Maybe they thought, you know what, I don't want to destroy a guy's reputation and career, cause him to lose his job, have him be unable to feed his family because he carelessly said a word that offended him that he should not have said. I don't know. Shortly after, plaintiff officially transferred to the Detroit taproom, searching for fresh beginnings with the company. However, similar racial incidents continued to occur in Detroit as well. Not in Detroit. Defendant admits that plaintiff accepted a promotion to become the events and promotions manager at defendant's soon-to-be-opened Detroit taproom beginning in October 2017, and that defendant selected plaintiff for this promotion out of 294 applicants for the position. I'll bet they can document that. So they promoted him out of 294 applicants. That does not support the plaintiff's allegation that they were discriminating against him, because if they were, then why didn't they then? Defendant denies that plaintiff took this promotion because he was searching for fresh beginnings. And who knows? Defendant denies all remaining allegations in the paragraph because they're untrue. In one incident, the employees were discussing ex-Detroit Mayor Kwame Kilpatrick. Following plaintiff expressing his views, a Caucasian coworker looked at plaintiff and said he needs to explain to plaintiff what it meant to be the head N-word in charge. Plaintiff immediately expressed his displeasure with the comment, to which the Caucasian coworker reaffirmed his statement. The plaintiff immediately notified General Manager Dominic Ryan and a Human Resources employee, Margot Beaucamp, who was present. I assume present at the workplace, not necessarily present when this was said. The two stated they were simply going to write the Caucasian employee up for the incident. Plaintiff expressed his frustration with the company taking a blind eye to blatant racism against him and allowing an overtly racist culture. Plaintiff also stated that Founders should not allow this to happen. However, nothing was done beyond the write-up. Answer. This is a long one. Defendant admits that plaintiff reported that a coworker made a comment similar to the one alleged in paragraph 19 to General Manager Dominic Ryan and Human Resources Representative Margot Beaucamp. Defendant admits that Mr. Ryan and Ms. Beaucamp told plaintiff that they would investigate his complaint, discuss the appropriate disciplinary action for the offending employee after completing the investigation, and follow up with the plaintiff. After completing its investigation, defendant admits that Ms. Beaucamp and Mr. Ryan took prompt remedial action, including issuing a written disciplinary warning to the offending employee and informing the employee that additional actions of this nature could result in termination of his employment. Again, Incident happened, verbal incident, plaintiff took action, warned him if this happens again, you're probably going to get fired. Defendant denies that Ms. Beaucamp and Mr. Ryan told plaintiff that they would simply write up the offending coworker. Now, here's what they're doing is they're picking at the editorial language in the initial complaint, because they're quoting him. The plaintiff is quoting them, saying they were simply going to write him up for the incident, as opposed to taking more dramatic action such as firing him. So they say no, they did not say they were going to simply write up the offending coworker. Defendant denies that plaintiff expresses frustration with the company taking a blind eye to blatant racism against him and allowing an overtly racist culture, or that plaintiff, quote, stated that defendant should not allow this to happen. Defendant also denies that there was nothing done beyond the write-up. Defendant denies all remaining allegations in the paragraph because they're untrue. So, again, it would be at a trial when there's an actual determination of whether or not this happened according to the one side or the other. But at face value, does this sound like what probably would have happened? Yeah, probably. A white employee said the N-word that they should never have said. The company, rather than firing him completely, said, if you do this again, you're fired. Don't ever do this again. And that's not necessarily the wrong thing to do. Later, plaintiff heard from other employees that the Caucasian employee was still making racist comments, including but not limited to a complaint about how dark the taproom's clientele, misspelled clientele, is. The employee is still employed. Answer: defendant denies that the employee referenced in paragraph 19 remains employed by defendant. Defendant is without knowledge or information sufficient to form a belief as to the remaining allegations in paragraph 20. Now, by the way, in all of this, the plaintiff is attempting to set the tone here, because he's saying this is demonstrating that there is this racist culture at Founders that leads to substantially show that my allegations that I was fired for being black have merit, because there's this pattern here. But that does not necessarily mean they're going to prevail in court, because the question that the judge or the jury is going to determine is, were you fired because you were black? Does this prove that or does it not? Plaintiff suffered because of Founders' intolerance for a racist internal corporate culture. Answer: they deny that claim. Further, the position, okay, again, this is the plaintiff. Further, the position itself was challenging, as plaintiff was expected to plan large-scale projects without any budget whatsoever. Additionally, in at least one instance, plaintiff had planned an entire project and obtained the permits only to have the entire event moved to another location, requiring completely different permits. Plaintiff was blamed for the delay despite the necessity of new permits. Answer: they deny that this is what happened. So, because now they're going to say, the plaintiff is saying, he shouldn't have been fired at all. Because the defense is saying you were fired because you couldn't do your job effectively. So he's saying, no, they were the problem, not me. Following the continued racism, plaintiff scheduled a personal day off on or around June 1st to drive to Grand Rapids to speak with Founders Human Resources personnel about the incidents and his work environment. The answer is they deny because it's untrue. And again, this would be determined at trial. On May 31, 2018, the day prior to his scheduled day off, plaintiff was called into General Manager Ryan's office to discuss an ongoing project that plaintiff was working on. General Manager Ryan urged plaintiff to finish the project and questioned plaintiff's choice to schedule a personal day on June 1st. So what does it sound like is happening here? There's a problem with some event that he's planning at the Detroit Tap Room. He says, I need to take a day off to go to Grand Rapids to complain about the racism that's happening here. They say, no, you got to finish the project. Well, let's see what they say here. The defendant admits on May 31st, 2018, General Manager Dominic Ryan told plaintiff that he needed to provide an event proposal for an event that plaintiff was attempting to gain defendant's approval to hold at defendant's Detroit Taproom. In further answer, prior to May 31st, defendant placed plaintiff on a development plan to address deficiencies in plaintiff's job performance as events and promotions manager by providing additional training to plaintiff and listing specific tasks for plaintiff to complete within certain timeframes. As part of that development plan, plaintiff was required to submit a complete event proposal to defendant for an event at the Detroit Taproom, but plaintiff repeatedly failed to submit a complete budget or provide any other necessary information in the event proposal that defendant needed to evaluate and approve the proposed event, despite defendant's repeated directions for plaintiff to do so. For instance, on May 22nd, General Manager Dominic Ryan told plaintiff that the event proposal he submitted was incomplete and lacking key information that plaintiff must submit a complete event proposal by May 25th. Plaintiff, however, did not submit the budget proposal on May 25th as required, so Mr. Ryan gave plaintiff until May 31st to submit the complete event proposal. Plaintiff also failed to meet that May 31st deadline, so Mr. Ryan gave plaintiff yet another extension until June 1st, that's only one more day, to provide a complete event proposal, but plaintiff failed to meet this deadline with a complete event proposal. Defendant denies the remaining allegations in paragraph 24 because they are untrue. Now, if you were Founders Brewing Company, would you assert this defense if you weren't prepared to back that up? I doubt it. We know that there's a human resources department. We see there's multiple staff. Here's a general manager. They claim that there was continued extensions. So what Founders is showing here, or what they're claiming, is that absent anything in the plaintiff's allegation in the initial complaint, they're saying, no, there's actually quite a bit of evidence out there that he was justifiably fired because he couldn't perform the job. We hired him in production. He was he applied to be transferred to working on event promotions, and it turns out, according to them, that he was unable to submit an event plan, and there's these other problems. So getting back to the complaint here, we're about halfway through this document, and then we can get into the aftermath, and that's when things get really interesting. So, in response, plaintiff explicitly complained that he scheduled the day off so he could discuss his treatment due to his race and the racist incidents he had witnessed with Founders Human Resources personnel in person. Plaintiff also expressed his frustration that the company continued to employ the employee who had said the word N-word and continued to make racist comments. Plaintiff stated to General Manager Ryan that he did not feel comfortable working alongside the employee. Answer: they deny that this was true. Let's say that it is. How does that look? It looks like he says, as the management is getting increasingly impatient with him that he doesn't have this event plan, he's now saying, I need to take a day off to drive to Grand Rapids to complain about the racist problems that we have here. They might think that something is amiss here. Maybe. So now, according to the plaintiff, General Manager Ryan reaffirmed that he needed something done on the project from plaintiff tomorrow, the day plaintiff explained that he planned to see HR. As a result, plaintiff postponed his scheduled day off for fear of retaliation. Well, it's not retaliation if you're given a deadline and you miss the deadline. Because they say, we need this event plan tomorrow, we've given you 2 extensions. You can meet with the general manager in Grand Rapids the day after if you want to discuss the issues of racial mistreatment. But that's not time sensitive. The event plan is. But moving on. Defendant admits that on May 31st, 2018, General Manager Ryan gave plaintiff an additional day to complete his already late event proposal. Defendant denies the remaining allegations in paragraph 26 because they are untrue. On or around the following Tuesday, plaintiff's first workday after his originally scheduled day off, plaintiff was called into General Manager Ryan's office. Upon entering, plaintiff noticed Human Resources Director Audrey Streeter was present. Plaintiff assumed the purpose of the meeting was to discuss the complaints he had made to GM Ryan a few days earlier. Instead, GM Ryan and Streeter informed plaintiff that he was terminated and handed him a separation agreement which plaintiff refused to sign. Okay, so they fired him. Answer. Defendant admits that plaintiff met with General Manager Dominic Ryan and Defendant's Human Resources Director Audrey Streeter on Tuesday, June 5th. Was it the same day? Okay, on or around. Okay, yeah, so Tuesday, June 5th, in Mr. Ryan's office at the Defendant's Detroit Tap Room, which was plaintiff's first day of work since Friday, June 1st, 2018. Defendant admits that at this meeting, Mr. Ryan and Ms. Streeter informed plaintiff that his employment was being terminated effective immediately and offered plaintiff the opportunity to receive severance pay by executing a separation agreement, which plaintiff later declined. Defendant is without knowledge or information to form a belief as to what plaintiff assumed this meeting was about. Defendant denies all the remaining allegations because they're untrue. As a result of defendant's conduct, plaintiff suffered substantial harm, including significant financial loss, embarrassment, stress, and frustration. Answer, defendant denies the allegations because they're untrue. On September 26th, plaintiff filed the charge of racial discrimination and retaliation with the Equal Employment Opportunity Commission. Plaintiff was issued his right to sue on October 1st, 2018. Answer is that's admitted. So those are the factual claims of the lawsuit, and now we get into the counts, which I'm going to mostly skip over because these are basically all the same thing. A kind of racial discrimination, kind of promotion on the basis of denying promotion on the basis of race, retaliation. And these are all the legal claims that you have based upon the facts. So they're saying as a direct, like as it says here, as a direct and proximate result of the defendant's unlawful actions, plaintiff has sustained injuries, including loss of pay, loss of vacation and sick days, loss of career opportunities, humiliation, embarrassment, mental anguish, emotional distress, loss of professional reputation, et cetera, et cetera, et cetera. So you have that, you've got racial discrimination, and these are all, actually the fourth one is in Michigan state law. The other three are in federal law. So there's federal laws against discrimination. There's also state laws against discrimination. So they're alleging counts on both of those. So for whatever reason, one of them is denied. For whatever legal reason, they can also fall back on the others. So you got retaliation, racial discrimination, denying promotion on the basis of race again, retaliation, racial discrimination, retaliation, and then you have the jury demand. And now we have the affirmative defenses of the defense. And basically, these are just blanket denials because, again, when there's questions of fact, they have to go to a court. They can't just simply say, this wasn't true, therefore dismiss our case. So they have these various defenses here. Okay, so they say the plaintiff's complaint in whole or part fails to state a claim on which relief can be granted. So that doesn't mean that firing somebody on the basis of race is not unlawful. What that means is they're saying the facts that have been alleged in the complaint don't demonstrate that. Therefore, the claim's not valid. Therefore, they haven't stated a claim. And they go on, and these are basically denials. And oftentimes the defense will make every possible denial, even if the facts don't really show it, because that way any one of these things can lead to the case being dismissed. So they want to reserve all of those opportunities. So they claimed they're barred to the extent they were not set forth in the plaintiff's administrative charge. They're barred because the plaintiff failed to mitigate his damages. And I'm not an attorney. I just play with the capital, so I don't know if these are true or not. But they're asserting these defenses. So that is the case as we know it up to this point. And again, there have been further documents in this case. They are public record. I have not acquired them, so this is as far as it goes. And this is as far as most people understood the case at the time. And at this point, it's he said, she said. They say this happened, he says that happened. And until you have a trial, you don't really know what the truth of the matter is. There's clearly disputations of fact here. So as an observer of the case, you have to say, we don't know what's going to happen. We don't know what actually happened. We weren't there. So you can only really speculate. But let's see what happens when this case goes to the media. Okay, so the Metro Times covered this story on April 8th. This is after that response was filed. There's now been a hearing. A judge says this can move forward to trial. So what happens next? Next, there is the discovery period. That's when each side can interview the other in what's called deposition. And if you're not familiar with what a deposition is, it's when the opposing lawyers interview they can interview witnesses, or they can interview the parties, the opposing party. And the opposing party has to answer all of their questions. It's not until the transcript of the deposition goes before a judge that the judge can say, no, that's not admissible in most questions. They have to answer them. And a deposition is public record. Either party can request a transcript, sometimes they can video them, and they can take those to the public, because unless there's some kind of court order for something to be sealed, court documents are public record. They can be obtained by the public. So what happens? The Metro Times reports on October 21st. So this is now almost present day. We're now less than a month ago. This is October 21st. This story breaks in the Metro Times, and as we'll see, it very quickly goes viral. So here's the story. There's Tracy Evans. Headline: Founders Brewing manager claims he didn't know the employee was black. And that's the employee. How can you look at that guy and not know he was black? Looks black, right? Well, let's see. Let's see what happened. Tracy Evans is black. This is the Metro Times. Tracy Evans is black. That's a simple, indisputable fact. Is it? He certainly looks black to me, but President Barack Obama looked 100% black. He wasn't 100% black. He was also part white, and I think part Asian too, wasn't he? But anyway, Tracy Evans is black. That is a simple, indisputable fact according to the Metro Times. He confirms he is. As we previously reported, the founder's employee's race is at the center of a contentious racial discrimination lawsuit that he filed in federal court last year against the Grand Rapids-based brewer. Evans, a former manager who worked at Founders Detroit and Grand Rapids locations, alleged a racist internal corporate culture. We heard all this stuff in the transcript, or in the complaint and the answer. So now, here's what's going on. The suit is moving through the trial process and is in depositions. That's where Founders revealed a startling and arguably ludicrous defense. The manager who fired Evans is claiming he didn't know that Evans was black. No, this is false. This was not a defense. This was an answer to a question at deposition. That's a critical distinction. We'll look at that in a moment here. A transcript of the exchange between Founders Detroit General Manager Dominic Ryan and Evans' attorney Jack Schultz shows Schultz shifting from shocked to incredulous and perhaps a bit angry, as Ryan claims he had no idea Evans is black. Instead of just answering the question and moving on, Ryan digs in deeper and deeper. Okay, Ryan is the manager, he's the deponent. Schultz is the attorney for the opposing counsel, the attorney for the opposing party. He is their counsel. Repeatedly asking for clarification when Schultz asks questions like, "Are you aware Tracy is black?" At one point, Ryan even claims that he doesn't know if former President Barack Obama, Kwame Kilpatrick, or Michael Jordan are African American because he has, quote, never met them. A transcript of the exchange shows the depths to which the exchange sunk. And now here is that exchange. Evans' attorney, Jack Schultz. When did you first meet Tracy Evans? Founders manager Dominic Ryan. 2011, 2012. We had mutual friends before working there. So now we learned something here. So Tracy Evans they knew him through a mutual friend, and they hired him much later. 2013, I think it was, late 2013. Again, this kind of works against the notion that they were racist because they deliberately hired him on the recommendation of a friend. So if they're so racist, why would they hire him in the first place? Okay, so you knew Tracy prior to his employment at Founders. We met a few times, yes. Okay, so are you aware that Tracy is black? Ryan, what do you mean by that? Schultz, are you aware that Tracy is African American? Ryan, I'm not sure of his lineage, so I can't answer that. That's an important distinction, and that's part of why he's answering the question that way. Let's say he didn't answer the way he did, and he simply said, yes, I'm aware that Tracy is black. Well, what's the next question? How do you know that? Because he looks black. Are you judging him based on his appearance? How do you know that he isn't 90% white and just happens to look black? This is the way these things can go. And this is the opposing counsel asking the client, or the opposing counsel asking the plaintiff questions for the purpose of using his answers against him in court. And his attorney is not allowed to advise him in the middle of the deposition on how to answer these things. So what does a competent attorney tell his client before a deposition? He says, don't answer any question that you're not clear about, because anything you say can be used against you at trial. It can be taken at face value. And, they're attorneys. Their job is to lead the jury to see it their way, in any way that they can. So what the general manager is doing is he's not conceding his knowledge of Tracy Evans' race, because he probably didn't, he really should not have asked it on an employment application. So if he doesn't know that, if Tracy Evans hasn't said to him, I am black, and why would he say that? People would just assume that he is. There's this photo. Most people would assume that that person is black. He didn't ask that. So if he said, I know he's black, that leads to the question, how do you know? And if you don't know, then why would you make that assumption? So what Ryan is actually doing here is smartly answering the question from the opposing counsel to avoid exposing him to risk at trial. That's not a defense strategy, as this article says. That's how you answer in a deposition to avoid exposing yourself to risk. He's actually very smartly following the advice of his counsel. But do Metro Times readers know that? No, if you're not an attorney or have some understanding of how the law works, you wouldn't. You see this headline: Founders Brewing manager claims he didn't know black employee is black. And throughout this story, as we read up to this point, that's the table that they're setting here. They're saying that this is Founders' startling and arguably ludicrous defense that the manager who fired Evans is claiming he didn't know that Evans was black. Now, this wasn't in their answer to the initial complaint, so that's not their defense. This is what they're saying at deposition. How do you suppose the Metro Times got this deposition? Did they FOIA it? Did they ask someone for it, or was it given to them by the plaintiff's counsel or the plaintiff? It's a good question. Anyway, so this exchange goes on, and again, the plaintiff's lawyer is trying to pin him down. I'm asking for clarification. You don't need any. I can promise you that. We'll keep the record as is. Someone's skin color, a white. So Ryan says, so that's what you're referring to? Yeah. Oh, yeah. Okay. Well, that's a question too. What if it was an Hispanic employee? You can be Latino and appear white. You can be Latino and appear black. You can be Latino and have olive skin. It's not entirely clear cut. So he's saying, no, race referring to skin color. Okay. So Ryan says, yes, I know the difference in skin tone. So now the opposing counsel says, so are you able to identify individuals by their skin tone? Aha. So, if you're watching me here, you probably think I look white, and I am. You see this guy, you think he looks black, and he is. But it's not always that obvious. So if you say to the opposing counsel, yes, I can tell what race someone is by their skin tone, that's going to work against you in a major way in court, and he's avoiding this. So here we go. What do you mean identify? Have you ever looked at Tracy Evans in your entire life? Have you? That's a genuine question. And the founder's attorney objects. It's argumentative. But he says you can answer. It's an offensive question. You just established that you knew the guy. But, that's how this goes. And did you ever realize that Tracy's skin is black? And again, he's trying to avoid being pinned down. That's not, is his skin different from mine? Yes. How? What do you mean how? It's a different color. And what is that difference of that color? It's darker. And that means, then attorney says, objection, vague question. So at that point, the deponent could say, you tell me what that means. You can't just say, and that means what? That's not a specific question at all. But here's what happens. Ryan says, I don't know Tracy's lineage. I can't speculate on whether if he's from Africa or not. Okay, so that's a linguistic distinction here. Because, we use the terms black and African American synonymously. But what about a black person from Jamaica? That would be a Jamaican American. Now, what about a Jamaican person that moved to Europe? He's not African American. He's a Jamaican Briton. So again, he's trying very carefully to avoid getting pinned down with these questions. So he says, "What do you mean lineage from Africa?" He says, "No, I don't know his DNA." Have you ever met black people who aren't from Africa? I have. I've met a Jamaican. Excuse me? Have you ever met a black person born in America? Yes. And have you met a black person who didn't tell you they were black? Can you rephrase that? Is Barack Obama black? That's a completely different question. Founder's attorney objects. Schultz, to your knowledge. Ryan, I've never met Barack Obama, so I don't. He says, you don't know if Barack Obama is black? What about Michael Jordan? Do you know if Michael Jordan is black? Founders objects again. I've never met him. And that's pretty much the end here. So now the Metro Times begins its editorial. Evans called Ryan's comments completely offensive and says he was surprised by the exchange, especially, and again, Evans is the plaintiff. This is the employee that got fired. Called Evans' comments completely offensive and says he was surprised by the exchange, especially because he was friends with Ryan at one point. Founders' management's refusal to recognize an African American and how he was being treated is the whole reason we are in this predicament. Evans tells the Metro Times. The Metro Times does not explain to the readers the context of a deposition and why a deponent would answer in this way. And they're just passing on Evans' characterization of the exchange. there's this blind ignorance, and to me, that's part of the larger story. He says a lot of these white-owned companies, and it's not just Detroit, it's all over the country, have come in and have this sort of blindness to avert racism, and it has to be called out. So he's waving the victim flag here. Evans adds it's not uncommon for white managers like Ryan to have, quote, have utter disregard for people of color and the things that we go through at their establishment. Okay, this is not part of the case. This is a comment to the media, but this is what would be worked through at trial if it came to it. How can one expect to know what minorities go through if they can't even acknowledge that some employees are minorities? So again, he's using the response in the deposition to bolster his narrative. Mr. Ryan was simply saying that he does not assume anything about individuals' race or... Okay, so this is now the response from the defense to the Metro Times. In a statement provided to the Metro Times, a founder's attorney seemed to double down on Ryan's strategy. And again, to call it a strategy in a deposition is kind of misleading because, yeah, I mean, you're briefed by your lawyer before you go into a deposition, but it's not a strategy. You have to answer the questions. You have to answer them truthfully. Denied that his claim doesn't see skin color as a defense. Quote, Mr. Ryan was simply saying that he does not assume anything about individuals' race or ethnicity unless they tell him that information. The statement reads, yeah, that's what he was trying to avoid getting pinned on, is saying that he knew he was black by the look of his skin. That's what he was trying to avoid. Smartly. Quote, while it might be acceptable to speculate about this type of thing in casual conversation, Mr. Ryan was not having a casual conversation. He was under oath when he made those statements. Exactly. Of course, at this point, founders had been served with a federal racial discrimination lawsuit that explicitly spells out that Evans is black. The defense can't assume that the claims in the lawsuit are valid because they're asking for what happened up to the point of him being fired. You know, the lawsuit's about that you were fired for being black, so you can't rely on what was in the complaint made months later to establish this. So we're going to come back to this in a moment. But this was the story in the Metro Times on October 21st. This story went viral. So we have story in NBC News. Exact same thing. They're going to, I think they reprint the deposition here. No, this is a shorter one. But this is October 22nd. And here's where, again, they're quoting from the deposition. Founder General Manager Dominic Ryan said he could not definitively say whether the employee was black. And again, to this one, at this point, they're not even quoting the deposition in the story. They're quoting the allegations in the complaint. All of this will lead the average reader to think, if this is true, oh my God, this is a terrible racist company. Here's a story in Newsweek. Leaked deposition, so the general manager of Founders Brewing Company saying does not know if Barack Obama is black. And by the way, this is the fake news here. This deposition was not leaked. The deposition is public record. So if it was obtained by the news, it wasn't leaked. If it was given to the news, it wasn't leaked. It's a public record. It's a public statement. It was given to them because they were going to use it to support their narrative. This is not a video from the case at all. I don't know why they have that there. It's just some kind of clickbait or something. But again, they reprint the exchange, provide no context for what a deposition means, call the comments offensive. So this is the national news at Newsweek magazine, which is no longer a magazine, but they're online. Daily Mail UK, same thing. And look at the shock that they expressed in the headline. Even though he knew him for 8 years because he doesn't see color and doesn't know his racial lineage. No, he was making the smartest defense you can in a deposition. That was what he was doing effectively. They go on, and again, the black guy printer, white guy printer thing. Going back to, do you believe there was a black guy printer and a white guy printer? Even before we looked at the lawsuit, what's the more likely story here? That the employee was fired because he was black, or that the employee was fired because he couldn't do his job? What would a smart company do? They would not fire an employee for being black. And And even if that was their actual intention, they would still have a well-documented, carefully constructed pretext. But that would be sorted out at trial. Unfortunately, this case, and I'm getting ahead of myself here, giving away the, maybe I won't spoil it. But we're coming to the end of the story pretty quickly here, because this was just a few days ago. This story has now gone viral. And as we see from the update from the Metro Times, just a few days later, dozens of local bars dropped Founders from their menus. On Friday, the company announced it was closing the Detroit taproom until further notice. It pulled out of the weekend's Michigan Brewers Guild Fall Festival. And also on Friday, Founders' Diversity and Inclusion Director Tracy announced her resignation from the company. Let's look at what happened there. So this is, what do we have here? Wait, I don't want to, okay, so yeah, this was already brought up. They closed their Detroit taproom. Boom. Damage. Immense damage from the publicity of the lawsuit. That's not good. Not good for Founders. They are now in a bad place. In fact, I think I saw that they were in the process of being acquired by a Spanish company, or being a majority acquisition from a Spanish company. I don't know if that had been finalized or not, but this would almost certainly throw a wrench in those gears. So who knows? Founders, the Brewing Diversity Director resigns, writes scathing letter to leadership. Now, this is published on October 25th, so this is just a few days after the lawsuit really starts making big headlines. So what happened? Tracy hired as Founders Brewing Company's Diversity and Inclusion Director last January, as Michigan's largest brewery was facing a racial discrimination lawsuit, said Friday evening on social media that she has resigned. Okay. So first of all, she was hired in January. The lawsuit was filed last year. That was probably an unwise move by Founders, because if you didn't previously have a diversity and inclusion director, now you're hiring one. That might work against you in court, because that then leads to the question, why didn't you have one previously? And by the way, they hired her apparently without some kind of non-disclosure agreement, because now she's going to say all of this. Posted her resignation letter directed to Founders on social media, blasting leadership for prioritizing winning a lawsuit over the well-being of its employees, customers, and accounts, and not practicing the principles the company set for itself. We'll comment on that in a moment, but let's see what she said. Quote, "Diversity is everything we bring to the table. Inclusion is ensuring we have a seat and a voice at the table. I knew what I signed up for regarding the lawsuit when I joined Founders Brewing Company. I have supported Founders each step of the way." Well, not this last step, but let's see. "I also know that I signed up to represent an organization that believes in its people, an organization that believes its people are family. I believed in Founders with everything I have." We'll see. "I believed in Founders to the extent of sacrificing my personal life, my safety." How so, your safety? "My friends, relationships with several community partners, and my health. Please explain. The case study I created, an interview process in which I was hired upon, drew specific measures to increase Founders' reputation in diversity and inclusion and regain the trust of the LGBTQ and people of color communities." We have not heard anything about any problems with the LGBTQ community. Is she pouring gas on the fire with that? What problems with LGBTs were there? "During my course of employment since January 2019, I have repeatedly given suggestions on how to build our reputation and listen to our employees who have been on the front lines. This week alone," by the way, if we can't compare something to a lynch mob, how can you compare this to battle? Please. "This week alone, I have repeatedly given explicit feedback on how to increase our reputation and increase our narrative, media reputation, and morale with employees. The feedback I have given is also the exact same feedback that credible public relations firms have given, which you blatantly disagreed with." Okay, this sounds like she gave them bad advice. Bad advice was admit wrongdoing and change your practices, which suggests wrongdoing. I wonder why in the world Founders didn't take that advice. in every conversation and with every action, you've been most concerned with winning the lawsuit. Yeah, they should be. If they lose the lawsuit, their reputation is destroyed forever. Yeah, they should be concerned about winning that lawsuit. You are most concerned with the ego of winning. No, you're concerned with the survival of winning. Then you are about the loss of customers, loss of reputation, loss of employees' well-being. I got news for you. They have lost customers, they have lost reputation, and they have lost employees' well-being in a major way as a result of all these things that have happened. This does not exemplify the founder's principles of family, community, authenticity, dedication, humility, positivity, purposeful progress, diversity, or inclusion. And by the way, I don't know what Founders' principles are. I've heard they're kind of a liberal company. I don't know if that's true or not. I find that breweries generally tend to be, because their clientele is, affluent, college-educated people who have these, these ideas, and whatever. So be it. I mean, all the more reason, by the way, if they are a progressive company, that it's unfortunate for them that they're being shamed by all these accusations, which may or may not be true. And we've been through the lawsuit. Do they sound to you as if they're true? But let's go on. We as a company didn't have to be at the place we are at now. And by the way, could any employee at any company who's a member of a protected class sue them for this reason? Yes. Yes, they could. And what does a company do if they're trying to avoid lawsuits? They try to avoid exposure to that. Now, they can't legally, but it's something that they have to keep in mind. It's something that people are going to think about. So, if the voice of a diversity and inclusion director was heard, headlines would read much differently. No, they wouldn't. No, they would not. If your advice was for founders to admit their guilt, that would be the headlines. That would be the headlines. We had the opportunity to be the hero in how we could have addressed the situation. Instead, we lost it. There should have been a semicolon there. Instead, we lost the trust of the community, many of our accounts, and many of our employees. That was happening one way or the other. And don't think if the company was to admit wrongdoing and say, yes, we were a racist company, we fired him because we were racist, but we're different now, we're better now, that people would just move on and say, you're the hero. Fat chance. Fat chance. We are not experiencing a staff issue. We are experiencing a leadership issue. Inclusion is ensuring we have a seat and a voice at the table. By the way, if you're a company and Tracy applies to be your next diversity and inclusion director, are you going to see this story when you Google her name and think, well, she was a great asset to Founders Brewing Company. She'll be a great asset to our company as well. Tracy, I might not have done this if I were you. Because what she's saying, essentially, is taking public her accusations that founders didn't take my advice, so I'm quitting, and I'm going to now also allege all these things. Your actions have explicitly shown you are more interested in the optics of my face than the impact of my voice. Here we go. I have dedicated myself to a life and career of equity, ethics, integrity, and morals. I cannot represent a company who doesn't stand for the same. Founders, just got that NDA. Ego and greed will destroy an organization's brand and reputation. This is my 2-week resignation. My last day with My last day with Founders will be on Friday, November 9th, 2019. I wish you all the best. So she still is collecting a paycheck for 2 more weeks. And then they go through it again. Founders closed their tap room indefinitely out of a bunch of caution for employee safety. They were concerned about protests, riots, violence, all agitated by the media, for a lawsuit that we don't know the facts about. And Metro Times didn't either. They knew what they were doing when they printed this headline, when they ran the story. This is great clickbait. This is good stuff. This supports a narrative that there's racial discrimination everywhere. Yeah, let's do this. But I promise you, if not Tom Perkins himself, the author of this piece, someone at Metro Times understands how depositions work and knew exactly what they were doing when they ran this story. NBC News knows what a deposition is. Newsweek knows what a deposition is. Daily Mail knows what a deposition is. But that was the narrative that they all ran with. So what did Founders do? Just days later, October 31st, 10 days after the story hit the Metro Times, settled the racial discrimination lawsuit for an undisclosed amount. This is a story with a sad end, friends. Founders Brewing Company is looking to put a racial discrimination lawsuit that made national headlines behind it. Founders, I got news for you. This isn't behind you. This is not over. Let's read the story. This is in the Metro Times. Taking a victory lap. Here's the Metro Times. The Founders settled the lawsuit out of court. Lawsuit over. There was some discovery. By the way, I forgot to show this. Let me see if I can find the statement. Oh, yeah, okay. This was the statement that Founders made the day the Metro Times ran the story. This is from the attorney for Founders. Mr. Perkins, the author of the story. Thank you for reaching out to Founders before publishing your column. Founders will soon be publishing its full response to Mr. Evans' claims when it files a motion to dismiss the case in its entirety. This motion will include documentary proof that neither Mr. Evans' race nor retaliation played any part in Founders' decision to end Mr. Evans' employment. I would ask that you reserve judgment or comment on this case until you actually see the evidence presented by the parties. Yes, that'd be a good thing. Good thing. That's why we have a legal system, to determine the facts and the law as it applies to them. In the event that you will not, I understand that a person unfamiliar with most of the facts in this case and the person unfamiliar with the obligations that individuals are under when they give deposition testimony might perceive Mr. Ryan's statement as noteworthy. It is not. Yes, I've been over that. First, as I doubt you're aware, Mr. Evans himself has testified unequivocally and under oath that Mr. Ryan is not racist and was his friend. Ooh, wow. The plaintiff said under oath, Mr. Ryan is not racist. That sounds like it contradicts his entire case. Huh. So whatever point Mr. Evans is trying to make by leaking deposition testimony to you, well, it wasn't a leak, it was a give-over, is undone by his own words. Second, this testimony is not Founders' defense in this case, as you allege. Good proper apostrophe use there. Founders evaluated and decided to terminate Mr. Evans' employment. Terminate Mr. Evans based only on his job performance. Mr. Evans' poor job performance will be apparent when Founders files its upcoming motion. That's the motion to dismiss, which was not filed. Third, through his testimony, Mr. Ryan was simply saying he does not assume anything about an individual's race or ethnicity until they tell him that information. And this was in the Metro Times. While it might be acceptable to speculate about this type of thing in casual conversation, Mr. Ryan was not having a casual conversation. He was under oath when he made these statements. As all deponents are instructed, Mr. Ryan was directed not to guess, assume, or speculate in his deposition. This is the reason for his answer. Right. The fact that Mr. Evans is selectively leaking this type of information to you indicates that, unlike Founders, he has no evidence to support his position in this case. Founders looks forward to its day in court, and now that discovery has closed, it is more confident than ever it will prevail. Okay, so discovery has closed. That's important. That means that there were depositions on both sides. There was an exchange of records, and Founders, when it made this statement, sounds very confident that it's going to win. So, why did they settle out of court? I don't know whether or not his attorney advised they settle out of court. I can only speculate. And again, I don't know who owns Founders right now. I don't know if they were a sole proprietorship. I don't know. I think they were partly owned by some other companies. I don't know if that arrangement with the Spanish company to buy them had been completed or not, or whether it was aborted or is still being discussed. But you can only imagine, with this torrent of news articles and boycotts and protests and closures, that Founders, perhaps their attorneys, but I would think it was the client's decision probably that, you know what, the best thing we can do is just settle this dang thing. And I don't know. Let's see. Let's see what the statements are, because this is very sad, guys. This is sad. Initially, founders said Evans' allegations were unfounded and that the company was confident it would prevail in court. But now the company has decided to settle with Evans for an undisclosed amount, according to a joint statement provided to Metro Times. Previously, Evans was asking for damages and fees in excess of $75,000. A statement from founders' co-founders Dave Engbers and Mike Stevens is below. Quote, "We are pleased to settle this case and focus on the future." So this is probably their decision. "Through recent discussions with Tracy, we listened, engaged in self-discovery, and reached common ground to make amends. We agreed that nobody be viewed at fault here. Most importantly, this serves as an opportunity to place our full attention on the work we now have to do as a company of more than 600 dedicated team members." Okay, so they're not 200, they're more than 600 team members, employees. "To rebuild our relationships. Significantly, we are committed to moving the cause of diversity and inclusion forward for founders. We want to make every employee to feel valued. We want every employee to feel valued, respected, and safe. We abhor discriminatory action of any type and believe that beer should bring people together and not divide." Now, typically in an out-of-court settlement, something like this is agreed to by the parties, where they agree not to disparage each other. They often agree not to discuss the terms of the settlement and how much money either side was awarded or what either side agreed to, or anything like that. But this statement, although it says they agreed that nobody be viewed at fault here, it's not Tracy Evans anymore who decides who's at fault. It's the court of public opinion. It's the public that's going to decide whether or not Founders was guilty of racial discrimination. And Founders, I hate to tell you, this statement does not help your cause. Prevailing in court, had you fought it and won, that might help your cause a bit. But this does not look good for you. And what does Evans say? Boy, that's a long paragraph. Evans. And probably Evans' attorney consulted with him on this before he released it. But here's what Evans said. "I am not going to say too much here, but I want the world to know the power we have when we step forward and make ourselves heard. Upon hearing us, businesses also have the power to make changes or not. I don't know what happens from here within the doors of Founders Brewing Company. I do know this. We have legal resolution, and we have started looking at how all of this is affecting human lives." Well, if any of this was affecting human lives, you're saying Founders did this. So whatever court settlement they had didn't preclude him from making this statement and, rubbing their faces into the dirt here. But he goes on. "I don't know what Dave and Mike have planned for the future, but I know that seeing color," that's a reference to the deposition, "and valuing people who they are and their collection of experiences is the mission. Blah. Learning from our mistakes is also part of the mission." So again, you're implying there was mistakes that they made. If this is not disparagement, then that should have been made a lot clearer in the settlement agreement. So Founders, I don't know what you got by this, but this is a victory lap, and it goes on. "When someone offers to change, as humans we have few choices, and I made the choice to see what Founders does and the path they are about to take." Well, what path would that be? If it would be, we admit nothing, you weren't fired for being black, you were fired for not being able to do your job, then why would they have to change anything? But if Founders is admitting they're making changes and they're making some kind of change, then apparently they did something wrong. This all is going to the suggestion that Founders committed wrongdoing. This is a terrible settlement agreement for Founders. This is horrible. Blah, blah, blah. "To those who are affected by all this within, Founders had nothing to do with this. I apologize." Yeah, you should apologize to them. You should apologize, because I'll bet a few of them are getting laid off. So tough luck for them. But I'll bet you made out pretty well with that settlement agreement, didn't you, Tracy? I'll bet you did. I'll bet you did. I bet there was a financial component that wasn't there. Because if there wasn't, then why wouldn't they just proceed with their defense? Moving on. "Craft beer is about coming together and celebrating our differences, and no dollar amount should make a company want to forget that. A company is nothing without its workers, and you deserve to be valued as such, and there should be a clear line of what those goals are. As there are still people working for Founders that I still love dearly, I hope for nothing but the best for founders in the future. I will also be moving on and continuing this fight around the world, as the issues I experience at Founders are not just a Founders issue, they happen everywhere. And I vow to continue to be a vessel to help both employers and employees become better at acknowledging, understanding, and dealing with them. Love you all. Thanks for the support, and let's continue to stand up for what's right. That is a victory lap if there ever was one. And here's the thing. This play worked out really well. Now, and by the way, there's one more post-epilogue, and boy, this is even sadder yet. Founders announces plan to reopen their Detroit tap room, donate profits following discrimination lawsuit. They will reopen their Detroit tap room in early 2020, the company announced, and they will donate 100% of its profits to charity, to Detroit community organizations and charities through at least 2022. That's a pretty big financial hit. So, and I don't know, when they open in 2020, are people going to come pouring in because their beer goes to charity? And they're all so happy that Founders has mended their ways. I guess we'll see. I guess we'll see. So, wow, all profits for 3 years to charity. Now, to be fair, Founders probably makes more money from beer distribution than they do from their tap rooms. So this may not be the hugest financial hit to them ever, but this is a near total loss for Founders. And if we go back to the complaint, to the facts that were alleged, and we go back to the statement that Founders' attorney made just 10 days earlier, it would appear that Founders had a pretty good defense had this gone to trial. So, what does it say that if you're not, and again, we don't know all the facts here. Maybe there was some bombshell evidence that Founders was discriminatory. I don't think there was evidence of there being a white guy printer and a black guy printer. But maybe there was. But if there wasn't, what does it say about legal strategy for a company that's being maligned in court allegations? Well, it's that this works. If you're not doing, if it doesn't look good for you in the court of law, take it to the court of public opinion, because you have a narrative, and the media will happily feed that narrative because the media has a certain, they want to play up this, that there's racism everywhere, because frankly, they're out to get Trump, and that absolutely plays into it in a big way. All Trump supporters are racist, all Republicans are racist, and on it goes. How do you convince the public that half of the American electorate is so racist that because they believe they take it as a self-evident absolute, of course Trump is racist, that there must therefore be racism everywhere, and they need a story to make that possible. This is a dangerous precedent. This is dangerous that any employee can seek redress of grievances and can make any claim. And if it's not going right for them in court, just take it outside of court. Go to the media. And not every company will settle. Maybe some will fight to the death. Maybe some of them will fight, and prevail. And then what do you do? But Founders settled. The next company might settle. So my message, I guess, to the local bars that dropped Founders from their menus, I hope this doesn't happen to you next. But your employees who observed this case, and maybe they lobbied you to drop Founders from the menus, they might be the next ones to file something against you. So think about that. And there's no happy ending here, folks, unless you're Tracy Evans. This is a real happy ending for him. But this is not good for race relations. This is not good for companies. This is not good for a legal system. We have a legal system to give the public a preferable option to mob violence and dueling and things like that you can redress your grievances in a court of law. You can resolve your disputes that way. It's a system that's evolved over thousands of years. And if you can now circumvent all of that by not having a trial, not having rules of evidence, not having a trial by not having a judgment from a jury of your peers, but instead just have a media outlet gin up an online mob to attack your business, to threaten boycotts, to call for protests, and to ultimately browbeat you into submission. That's a very, very dangerous precedent, because you're making the legal system obsolete and you're replacing it with what essentially is mob justice. People see this story, they get outraged, they make threats. Companies count out of those threats, they drop founders from their menus, and pretty soon Founders has no better option. A legal dispute might drag out for years. Maybe their best option was to settle. Maybe. I don't know. I'm not their counsel. But I do know that because of this outcome, this is not the last case that was like this. So with that, I'm going to close up the stream. I don't know how long I've been going for. Oh, there I do. 1 hour and 20 minutes. So this was my first stream. It went on for a long time. I hope it was interesting for you guys. I hope I didn't say anything that got myself fired. But we'll see. We'll see how it goes. I think this is an interesting story. I don't think anybody in the media has been reporting this from this direction, even though the attorney flat out made the point that this is a misleading representation of what a deposition is. And the media should have known that. They probably did know it. And it's, as I say, it's a very sad story. And I hope that people take this story to heart and think about what they might do if this were to happen to them, and what they might do to prevent this from happening to them, which I hope absolutely does not include being discriminatory and not hiring people based on their race because you don't want to be exposed to lawsuits. I fear that will happen. I absolutely do not encourage it, but it's a sad thing. And frankly, if Tracy Evans was so concerned about race relations in this country, I think that stirring up the pot and putting this into the media was not the helpful thing to do. So with that, I'm going to sign off. I hope to have more YouTube episodes and talk about political issues, legal topics like this. I hope you like it. This is a brand new channel. I've never done a YouTube podcast ever before, so I hope it went okay. And of course, I have seen from other YouTubers, it's a smart thing to say, if you like this content, please subscribe to my channel and subscribe and post comments and share, share it, all that good stuff, because it's the only way I'm ever going to get any exposure for this. So I hope this was helpful to you. I hope this was entertaining. Thanks again for watching. Have a good night.